Good evening. My name is Jami Coleman. I am the owner and founder of Coleman Law. And tonight we are having a live Q&A and discussion about breaking the cycle, how estate planning protects Black families and generational wealth. Um, and I am excited to be here tonight. It is not great weather right now in Tallahassee, but I wanted to, um, still be present to be able to answer your questions and go through this seminar. So, as I move along, please feel free to ask questions, raise your hand, um, join in. I want this to be an interactive discussion. So I want to share my screen, and let's do that. All right. Okay, so tonight's webinar again is about breaking the cycle, how estate planning protects Black families' generational wealth. And I wanted to give you a little bit about me. Again, I'm the founder and managing attorney at Coleman Law. We're based out of Tallahassee. I am a proud mother of about 8 children. And so of course that is the pride and joy of my life, my children. And so it's also the reason why it's especially important that we protect our families. And so one of my passions, of course, is protecting families because I'm a mother. But at Coleman Law, we deliver high level legal strategy with empathy and care. We're very passionate about estate planning and making it accessible to everyone. Um, in an effort to empower them and to educate them. And we also are very passionate about both legacy planning and asset protection for your family. And so you can see a little pictures of my kids and my parents. And so what do we do here at Coleman Law? Our practice focus primarily on estate planning, probate, tax, business matters, real estate, and we also help with guardianship matters. So 67% of Black Americans have no will or estate plan. And because of that, we are 2 to 3 times more likely to lose generational wealth because we don't have a plan. And so when that happens, we lose money that goes to our heirs when we have to go through probate or when we have essentially no planning tools in place to help get our assets to our loved ones. Um, and so what I've known or seen rather in my career is that um, probate can be costly. It's also time consuming. And so what happens is em- you employ an attorney like myself to assist with getting a deceased person's name off an asset and into the heirs' names. Um, and because of that, you're going to be paying an attorney. You're also going to be paying court costs. And so when that happens, the money that you would have going to your loved ones is lost to attorneys or court fees because you haven't done proper planning. And so we want to avoid that. So if you're here at tonight's discussion, I want you to, um, I'm thankful that you're here, but I want you to be empowered enough to have an estate plan in place so that less money goes to attorneys and more of it goes to your family. The average probate can take anywhere from 1 to 2 years. At Coleman Law, we really strive to have that done within 3 to 6 months, if possible. Some probates are contested, and so when they're contested, it does take a while because you have people who are challenging the probate, and those challenges, whether you believe they're meritless or not, they have to be dealt with. And so administration can take longer than normal. But when you have things such as a living trust, or even a plan in place, your assets can be transferred immediately and privately without court involvement. One of the things that happens in probate is your assets is the public record. And you also are waiting to hear from a third party like the court. And so when you have a plan in place, be it a will with a ladybird deed, a trust with a ladybird deed, some global plan for your assets, then you can avoid the wait and the third party. And so, one of the very first documents that I believe everyone should have is a will. And I believe a will does three things. The will tells the world, how do you want to be buried? Who do you want to designate as your personal representative? And where do you want your things to go in relation to the people that you love? And what I like to remind people is the will is not private. When you pass, it gets filed in the public record, and it should be filed at least 10 days after you passed. Um, but the benefit of having the will is that it tells the world what it is that you want to accomplish, what your goals are. And so the personal representative, that's a very interesting role. That role is usually someone close to you or that you trust to handle your affairs after you're gone. They're empowered to disperse your assets as you have indicated in your wishes or your plan. Okay. And they can also finalize your burial arrangements, but this is the person that steps in and takes care of things for you when you're gone. This is very different from your durable power of attorney, and we'll get to that a little later. But I wanted to just kind of stress the difference because many times I'll get people come up to me and say, "Hey, I was the power of attorney for my aunt's things, therefore I should be the personal representative, or therefore I should be the beneficiary." And they're not the same functions. And so your personal representative is the person designated in your will that takes, or if you don't have a will, that takes control of your assets and disperses them. They also pay creditors. They distribute assets to beneficiaries. So um, that is the person you're going to empower in your will to direct your wishes. The second document that I think is the most important document in your estate plan, um, I'm sorry, it is the most important document in your estate plan, is a power of attorney. So when we're talking about your estate plan, we're not only talking about your assets and what happened to them after you're gone, but we're also talking about protecting your assets while you're here. And so when you have a durable power of attorney in place, that agent is what we call them, can step into your shoes if you're incapacitated. Maybe it's because of a physical situation or a mental situation, and they can handle business for you. They can pay bills, they can sign deeds, they can get into your email, they can talk to the IRS, they can talk to Social Security, they can get with the insurance company if there's a claim on your home. They can act like you. And you really want to make sure that you trust this person implicitly with your money, because this is a very important role, and this is one that would potentially wipe you out. So if this person is not um, uh, trustworthy, or maybe they don't handle their finances appropriately, then you may not want that person to serve as the agent as your durable power of attorney. Okay. So again, make sure you trust that person implicitly. But the benefit of having a power of attorney, if it is because if for some reason you become incapacitated, like I mentioned earlier, maybe physically you're not able to handle your business because maybe of a stroke or some physical ailment. Maybe mentally because of dementia or Alzheimer's or memory loss. Um, this person steps in and handles it for you, right? And so this is a great alternative and a cheaper alternative to guardianship, which is another legal process. Guardianship is a process where the courts are involved. The proposed guardian has an attorney. The proposed ward which could be you if you're incapacitated in some way, has an attorney. And three members of the community come out to evaluate you to determine whether you have capacity or not. They make recommendations and reports, and then they issue it to the judge. And then the judge ultimately decides whether you're determined to be capacitated or incapacitated and to what extent. And that's a very long process. And it can cost a great deal of money. And who pays for it? The person that needs the guardianship. And so, if you have someone that you trust implicitly, having a power of attorney will save the time and expense in a guardianship. Now, with that being said, if you don't have someone that you trust implicitly, guardianship is a very safe way to go to have someone manage your affairs for you while you're living, because there's court oversight. They're going to review every dollar that's spent. They're going to look at your plan. If you're going to the doctor, you know, they're going to scrutinize whatever transactions occur in your account. So having a guardianship is a great alternative if you do not, is a good process rather, if you don't have someone you trust implicitly. But for those that do have someone, you should definitely have a durable power of attorney. The next document that I think everyone should have in their estate plan is the healthcare surrogate. And also the fourth document would be the living will. Now, sometimes these documents can be in the same document, these two, but I like to keep them separate. I like to have a healthcare surrogate and a living will. And so a healthcare surrogate is someone that is named in your documents as an agent that can make medical decisions for you, and they can get medical information. So they can talk to your physicians, they can help to make medical decisions for you. They would be privy to your medical records. And so I encourage everyone to appoint a healthcare surrogate and to give that document to their primary physician. Your living will talks about essentially if you're in a permanent vegetative state and there's no probability of recovering, do you want to be kept alive by artificial means? And so I encourage everyone to make that decision themselves. Don't leave it up to your family to make the decision to prolong your life through artificial means. I think it can cause division amongst family, especially if you have a family of more than just one. It can also cause guilt, render guilt. And so you make that decision yourself so that they don't have to deal with the turmoil that comes with, should I let my loved one go or should I keep them living through these artificial means. So trust. I get this question all the time. What are trusts? What are trusts? Trusts are another way to not only protect assets, but also to safeguard them away from the probate administration if they're done correctly. Um, Not everybody needs a trust, but they're good ways to avoid probate. There's so many types of trust though out there. And so not there's not a one size fits all thing, but there's the benefits of having a trust. I also like to think of trust as a way to impose conditions when you're no longer around, right? So if you're gone, how do we make sure that your wishes are carried out and the conditions upon those wishes are carried out? And a trust is a good way to do that. And so um, one of the I have a slide up here that talks about the differences of them. I get the question all the time, should I have a will versus a trust? I think everybody should have a will, but not everybody needs a trust, right? So let's say you have only one child, one real estate, one bank account, and you want to make sure that child gets the real estate and the bank account outright. Well, you may not need a trust. Instead, you may want to consider a ladybird deed, which is something we'll talk about in just a moment, or um, and making sure you have pay on death beneficiaries on your bank account. Okay. Having a pay on death beneficiary on your bank account ensures that your loved one or the person that you want to make sure that the bank account goes to gets the funds immediately upon your passing. All they'll have to do is provide the death certificate and their ID, and they'll get the funds. No need to put your account in a trust. Um, when it comes to your real estate, your home, well, you could do a ladybird deed and give it to that person outright. No need to put it into a trust. But if you are trying to um, impose conditions and you want to stay in control, having a trust is a good idea. They are typically more expensive than a will, but they can save your family absorbent costs in probate later down the road. So, and planning does that in general. If you go ahead and start your plan now, you can always save money with probate later on and potentially avoid probate altogether. So I talked about there's different types of trusts. There are revocable living trust, there are irrevocable trust, and there are testamentary trust. So what are those, right? So revocable living trust is a trust that is living outside of you. It's almost like a separate entity, although you don't need your own EIN number or separate EIN number. But it is a trust that you create and you can fund it and you can change it as much as you want as while you're living. An irrevocable trust means you really can't amend it. Now, there are always exceptions to that rule, but typically it's a trust that you can't amend. And sometimes we see in irrevocable trust life insurance proceeds in it. It's a trust that's going to produce some asset protection. But you can't really change your mind or take a lot of control when it comes to that type of trust generally. Testamentary trusts, those are trusts that are created in your will. And I like those trusts, quite honestly. Before I got married, I was a single mom and I had created testamentary trust for my children. And in that trust, I would impose conditions as to when they would get their inheritance. They would get it at a certain age in intervals, so they wouldn't get it all at one pot. And I still think those are good ideas, whether you're single or married, especially when you have young children. If you're worried about your children getting a lump sum amount when you pass, well, then having a testamentary trust or even a revocable trust that lays out conditions as to when they get it is a really good idea. So those are trusts again that are created within the will. So why would we choose an irrevocable trust? I mentioned earlier, and I just have a little expansive benefits here. Um, an irrevocable trust does have asset protection. It's generally used for high net worth individuals. Um, it helps with Medicaid planning. It also helps with special needs. So if you have a family member that has special needs and you want to create a trust for them so that they don't they can continue, excuse me, to keep their funding through the government, or if they're receiving some type of government benefits, having a special needs trust will help to prevent them from losing the funding or government benefits that they may receive. So there's lots of benefits of having an irrevocable trust. This is just some. But I generally get this question, why it's revocable versus irrevocable? And this is just some higher level reasons for why you want to consider an irrevocable trust. So revocable trust. When are they better? Well, you have flexibility. You can amend them and change them as much as you want. When things are titled appropriately in the trust, you can avoid probate. Also, there's privacy. Your trust doesn't necessarily get filed in the public record like your will would. So there's that benefit. And then a successor trustee can also manage your assets if you become incapacitated. That's another benefit. So here's just a little chart about what the differences are, generally, they both can avoid probate, the revocable and irrevocable trust. You have more control with a revocable trust than you do with an irrevocable. Um, there's generally no asset protection in a revocable trust. And there's no Medicaid planning when a revocable trust, unlike an irrevocable trust. So these are, again, high level. Of course, everything is nuanced and there are exceptions to the rule, but generally, these are the differences. So, my favorite subject, just about heirs property. So, what is heirs property? Heirs property is property that is owned by two or more relatives, right? And sometimes it can be property that is in the deceased family member's name and multiple people have an interest in it. We all have the story of grandmother's house, the house that is in grandma's name, everybody lives on the property, but maybe one person is the one paying the taxes, or a few of people are paying the taxes. Well, in this scenario that I have up on the screen, grandmother passes away. She has five children. Those five children pass away, and now 15 grandchildren own that house. And now every heir, because they're not necessarily attached to it, wants the cash. Maybe you have some heirs that don't. They just want to hold on for sentimental value. Um, but one of the heirs files a partition action, the property is sold, and the house is gone. In 2020 or 2019, I was very fortunate to be a part of a thinking group that helped to pass legislation called the Heirs Property Act. It's now Chapter 64, Part 2. And what that Uniform Heirs Property Partition Act does is it allows for a few things. One, if an heir wants to be bought out of the property, the other heirs can buy them out at their respective interest. So you no longer have to put the entire property up for sale. You can buy out the heir that does not want to stay an owner of that property. So prior to 2020, if you had one or more, two or more heirs that did not agree on what to do with the property, then the entire property would go up for sale and everybody would lose the property. But now, if you have one heir that says, hey, I don't want to be co owners with you, they still have the right to have their property sold, but it's only their interest. So let's just say you have, and I had a case recently where you had three owners of a property, one had a half interest, and the other two each had a one-fourth interest. The other two that had a one-fourth interest did not want to own the property anymore. So as a matter of right, they can sell their interests. They don't have to be owners. They don't have the right to sell the home generally, but they do have the right to be bought out. And so what happens is that my client who had the one half interest offered to buy the other two brothers out at their one-fourth interest. And so prayerfully, I get an order on that case very soon. Um, and so that's how that works. That heir that wants to be bought out essentially gives the other heirs the first right of refusal. So one, not only is the home, not only does the entire home stay intact and you don't lose the property because you can buy out the other heirs in their respective interests, but the other heirs that don't want to be bought out get the first right of refusal. So they can buy you out before the market or the public can. And then the other thing that the Uniform Heirs Property Partition Act does is that it also allows for the home to go up for sale. So, assuming nobody wants to buy the property, it goes up for sale on the market. So, the market gets an opportunity to compete or put bids in or make offers on the property, which is better for the families, right? Prior to 2020, the property could be sold on the courthouse steps or at auction, and you may not get the full market value of the home, thereby kind of exacerbating not only the loss of the property, but the value of the property too through partitions. So we're seeing a change in how partitions are dealt with. Courts are still getting used to Part 2 of the Uniform Heirs Property Partition Act. I always get it tied up. But it is a tool that's available out there for you if you find yourself unable to agree with your co-owners. So this is just a legal definition, excuse me, a non-legal definition of heirs property. You know, colloquially, we think of it as just property that's owned with a number of relatives, but it's property that is usually owned by two or more co-tenants that are related. Um, and so among Black families, especially in the rural areas, we see a lot of heir property issues. And having or not having a plan contributes to it. So I talked a little bit about the Uniform Partition of Heirs Property Act. Um, I believe a lot in this act. I think it's going to help have more families keep their properties intact and away from predators. What we saw prior to this act is that you would have investors go in and they would buy a fractional interest in the property. And then because they own a fractional interest, the entire property would go up for sale. And since the act has been signed into law in the state of Florida, as well as other states around the country. What you're seeing is other co-owners buying out their family members and keeping and retaining the property. Um, and so here's just a little quote. The best way to avoid a partition lawsuit is proper estate planning before the property passes. um, Having a plan is so important. And again, not every document is going to be what you need. But talking to someone about what it is that you desire, what your goals are, will help to formulate a plan that best suits you and your family. So I talked about what happens in a partition lawsuit. You know, the courts get involved. It is a lawsuit. And so you are suing someone. Litigation can be costly. You're paying attorneys. You're also paying for the court process itself. And so because you're paying fees and costs, um, that can be cost prohibitive. You also have family conflict. And then for some, it's a forced sale and it's a loss of generational wealth. So we want to avoid partitions. Quiet title actions are another type of lawsuits that I see and assist people with as it relates to their families. Um, it's used to clear ownership issues so that title can pass appropriately or be named appropriately on the property, and so that it can be sold, the property that is financed or transferred. Common issues that occur that would warrant quiet title actions: probate family problems, missing heirs, tax deed issues, unknown heirs, family inheritance disputes. These are just common issues that I see when we're doing quiet title actions. Another small quote: that good estate planning today can prevent expensive quiet title litigation tomorrow. And so deeds, let's talk about deeds, right? There's all types of deeds. You have warranty deeds, you have quitclaim deeds, you have ladybird deeds, you have, which is the same as an enhanced life estate deed, and you also have life estate deeds. So what is a warranty deed and why is it different from a quitclaim deed? A warranty deed is typically a deed that says that you're going to ensure and warrant that any issues that the grantee, the person you're giving the property to, has with title, you're going to defend. A quitclaim deed is a deed that says, hey, if I have any interest in this property, You now have it. Sometimes a quitclaim deed is not worth the paper that it's written on. So you really have to be careful about that because someone may not have an interest in that property, yet they're giving you what they don't have, or they're giving you what they have, which may be nothing. And so be a little leery of quitclaim deeds. They're not bad tools, but sometimes, and what we see as practitioners, is that people will give away property they don't really own in a quitclaim deed. A ladybird deed and a life estate deed, so forgive this typo, it should be a life estate deed, is different. So generally, a life estate deed is a deed that says, hey, I own this property for my lifetime. I can rent it. I can be the only one that lives on it. But if I want to sell it, then I have to get the remainderment to agree to it. That's the consequence. But the life tenant has the ability to use the property for their entire lifetime. They manage the property, they can collect the rents and the profits from that property, and they don't have to share with the remainderment. But when they pass away, the property is given to the remainderment. An enhanced life estate deed or a ladybird deed is a little different. It basically says, I own this property for my lifetime. I could do whatever I want. I could sell it, I could rent it, I could do whatever I want. But if I still own this property at my passing, this is who it goes to, or this is where it goes to. And so the life tenant remains in control. They don't have to get with the remainderment to make decisions like financing or selling the property. They still have that control. But they also have the ability to pass the property down free of probate once they pass. And that's the beauty of having a ladybird deed. And so if you own real estate, I really want you to consider having a ladybird deed, okay? Again, you retain complete ownership, you preserve your taxes, so your taxes on your property taxes don't go up just because you do a ladybird deed. You retain the right to sell. You can change beneficiaries. That's another beautiful thing about ladybird deeds. Let's say I have the property going to my son, and maybe things change in our relationship and I don't want to give it to him anymore. Well, now I can change my mind without my son being involved and give it to my daughters. So you can change your mind as it relates to the ladybird deed. It also avoids probate. So remember, I was telling you that a trust is not the only tool that can avoid probate. Ladybird deeds, when you own real estate, can avoid probate. Keep in mind that when you don't have a will, Florida will leave a will for you. And when you don't have a plan and it comes to real estate, your property may have to be dealt with in probate if you don't have a deed conveying it to someone after you're gone. Having a ladybird deed or putting the property into a trust could avoid probate. So here are some differences between a ladybird deed and a trust. Um, you know, they're much, much cheaper. Um, and they work really well if you have homestead property or you have property that is your primary residence. Trusts can be a little bit more complicated. They do manage more than just typically more than just one asset. So you wouldn't want to put conditions in your ladybird deed. You would want to put those conditions in your trust. So, business succession. Tonight's webinar is all about preservation of wealth and protecting your families. So, a lot of times we're business owners, we don't have plans ourselves for our business. Do we have operating agreements? Do we have buy-sell agreements? Have we created a trust, or do we want to create a trust for ownership? What happens to our business when we pass away? Do we have adequate life insurance for our business? What does succession look like for management? So, having these discussions and thinking them out is especially important. And if you're owning a business such as a church, a trucking business, a construction company, a barber shop, restaurant, a law firm, I want you to have these conversations with your attorney and your family. what happens in the event that you're no longer around to run the business? And maybe you're here, maybe you're just disabled or unable to run the business and manage the business as before. What does succession planning look like for you? So another issue that comes up in planning is children. Who raises them? Who manages their inheritance? How much court involvement is necessary? And so these questions come about um, in in planning about guardianship, about uh, who manages your children's funds, who's going to make sure who takes care of your children. So having a guardian designations in your estate plan, especially when you have minor children, is very important. So you definitely want to consider that. When you have those types of designations, what I what happens is that you could avoid guardianship altogether when there's proper planning. So, for those that have minor children, consider having something in your documents that talks about who raises your children, who handles their medical and educational needs, who will manage the money when you're gone. Some tools that we like to have in place is a preneed guardianship designation form. Your last will and testament will also have that type of language in there. And there's also trust planning for minor beneficiaries. So those are some tools that you can employ now so that a court doesn't have to get involved later when it comes to minor children. So, in celebration of Juneteenth, um, definitely have a will. Everybody should have a will. A will again tells the world what your needs are, what your desires are, what you want your wishes to be, how you want them to be effectuated. A trust is a good tool when you want to impose some conditions and also protect your family. A ladybird deed will avoid probate and it'll also allow you to keep control. And business succession, if you own a business, is always a great discussion to have and to contemplate when you're thinking about your estate planning. And so we talked a little bit about, or I discussed a little bit about minors and guardianship, but what happens if you're incapacitated? Um, if you're incapacitated and you can't handle your business affairs, your legal affairs, then a court gets involved in a guardianship. And a court will appoint someone to pay your bills, manage your property, access your accounts, make decisions for you. So, in an effort to protect your home and your assets and your body. You can avoid that type of expense that comes with it if you have advanced directives in place, such as a power of attorney, a healthcare surrogate, a living will, and even a trust. When you have those advanced directives in place, you can avoid guardianship altogether. The key there is that you really want to make sure that you have someone that you trust implicitly to handle these matters for you. Because if you don't, guardianship is not the worst option. So, breaking the cycle. Plan today so your family never has to lose grandma's house. Plan today so your family can always retain the wealth that or at least for a long time, retain the wealth that you've worked so hard to create. And so I want to thank you for joining. I want to just open it up for any questions if you have any. Um, this is this session does not mean that I'm your lawyer, but it does allow me to answer any general informational things, general questions you may have. So this is only for informational purposes only, and I'll open it up because I do want this to be interactive and I do want you to have your questions answered. Okay. Well, if there are no questions, thank you again for being present. And thank you again for your pouring into Coleman Law. I hope everyone enjoys Juneteenth. And if you happen to watch uh, this webinar and you're not a current client of ours, please join us, give us a call, let us know that you uh, joined the webinar so that we can offer you a special discount for any new clients. So thank you again for your time, and I look forward to seeing you next time.